Justice Scalia explained this outcome in his dissent from Mistretta, in which the court had upheld the constitutionality of the Sentencing Commission over a challenge based on separation of powers. He explained that although the non-delegation doctrine is, quote, unquestionably a fundamental element of our constitutional system, sounds familiar, because no statute can be entirely precise and some judgments must be left in the officers executing the law and to the judges applying it, the debate over unconstitutional delegation becomes a debate not over a point of principle, but over a question of degree, close quote. Such a determination involves, as he said, multifarious and, in the nonpartisan sense, highly political considerations as to which the Congress and not the court has the institutional competence. Among those considerations, Justice Scalia included whether the nation is at war or faces some inchoate emergency. Now, claims of emergency are indeed matters about which the court is properly hesitant to second-guess the political branches. But Justice Scalia's explanation is not convincing. The separation of powers is not a highly political consideration wisely left to the political branches. It's a fundament of the constitutional framework within which the political branches are supposed to operate. No meaningful concept, even of necessity, much less of emergency, could justify routine delegation of the lawmaking function to agencies and courts. What is needed, or what was needed, if it's too late to rescue the non-delegation doctrine, is a Supreme Court that both heeds Madison's warning about the propensity of the legislative power to dominate the other branches and, in response, develops a judicially manageable standard for distinguishing excessive or unjustified delegations from those meeting, as Justice Taft had put it, the inherent necessities of governmental coordination. What is needed, in short, is a court that recognizes that the non-delegation principle, although it, like judicial review itself, is more structural than textual, is no less for that a part of the judiciary's charge to uphold the Constitution. Instead, the judiciary, shrinking before the authority of the legislature, has been complicit in allowing delegation run riot. If the judiciary failed to resist the encroachment of the Congress, then what can be said of the executive? In their recent book, The Unitary Executive, Professor Steve Calabrese, a founder of the Society, and Professor Christopher Yu remind us that every American president has asserted the right to direct the activities of the executive branch free of congressional interference. But that only makes one even more curious. How is it that although every president insists upon the unity and independence of the executive, that branch could be transformed into a junior varsity legislature, issuing innumerable regulations according to no intelligible principle dictated by the Congress, yet having by judicial interpretation the force of law? The fragmentation of the executive, despite both its unitary pedigree and the uninterrupted efforts of American presidents, can be a mystery only to those who focus on the formal lines of authority rather than political reality. Political scientists have long recognized that formally allocated powers are no guarantee of actual power. As Richard Neustadt trenchantly observed, the President of the United States has an extraordinary range of formal powers, but despite his powers, he does not obtain results by giving orders, or not at any rate merely by giving orders. Presidential power is the power to persuade, close quote. Presidents commonly have very little contact with agency heads, let alone lesser policymakers, and hence very little opportunity to persuade them. Instead, policymakers interact with and are open to persuasion by and become the clients of others, of congressional committees that oversee their work, of the industry they regulate, of the trade press that reports their every word, and of the permanent bureaucracy over which they nominally preside. The influence of these constituencies reinforces the natural tendency of an agency to pursue a maximalist agenda within its own narrow field of authority and without regard to competing values, let alone the objectives of the rather remote President of the United States. Considering the forces arrayed against the President within his own branch, I recurred to Madison's insight that the weakness of the executive may require that it should be fortified. Perhaps the most vigorous and most effective proponent of an expansive administrative state, Franklin Roosevelt, was acutely aware of the need to shore up the executive against the Congress. His Committee on Administrative Management, commonly called the Brownlow Committee, recommended, with the President's enthusiastic support, the integration of the so-called independent agencies into the executive departments. The committee observed, the Constitution places in the President, and in the President alone, the whole executive power. Yet governmental powers of great importance are being exercised under conditions of virtual irresponsibility, close quote, by regulatory commissions beyond the President's direction. The Brownlow Committee's report seems as fresh today with financial regulation and health policy on the front page as it did in 1937. Listen. The commissions produce confusion, conflict, and incoherence in the formulation and in the execution of the President's policies. The President is held responsible for the wise and efficient management of the executive branch of the government. The people look to him for leadership, and yet we whittle away the effective control essential to that leadership by parceling out to a dozen or more irresponsible agencies important powers of policy and administration. So the committee concluded that the independent agencies that should become a fourth branch of the government had no sanction in the Constitution and had begun to, quote, defeat the constitutional intent that there be a single responsible chief executive to coordinate and manage the departments and activities in accordance with the laws enacted by Congress. The committee, interestingly, invoked, although implicitly, the Lockean non-delegation principle that stood behind the constitutional design. Power, they said, without responsibility has no place in a government based on the theory of democratic control. For responsibility is the people's only weapon, their only insurance against abuse of power. In other words, the people having delegated legislative power to the Congress, that power could not properly be delegated further to an unelected and potentially unaccountable agency. Delegata potestas non potest delegari. The Brownlow Committee's recommendations represented the executive's attempt to maintain the constitutional separation of powers through a robust non-delegation doctrine on the one hand and a unitary executive branch on the other. President Roosevelt said in transmitting the report to Congress, "What I am placing before you is the request not for more power, but for tools of management and the authority to distribute the work so that the President can effectively discharge those powers which the Constitution now places upon him. Unless we are prepared to abandon this important part of the Constitution, we must equip the President with authority commensurate with his responsibilities under the Constitution." To be more precise, but perhaps a little less diplomatic, President Roosevelt was asking for authority commensurate with his responsibilities, not for that, but for a rollback of the Congress's encroachment on his responsibilities. The Congress, of course, did not agree to decolonize the executive. Now, in this respect, the New Deal really does represent what Cass Sunstein's called an unfinished revolution, though not in the way, perhaps, that he had in mind. Roosevelt wanted the authority of the executive dispersed among specialized agencies subordinate to him, to the President, so the President would be presented with conflicting policy advice, disagreements, and options. That's precisely the circumstance in which the President can most effectively exercise his power to persuade, as the ultimate decision maker, by mediating intra-branch disputes and by shaping final agreements. Richard K. Betts at the Naval War College wrote of Roosevelt that he used bureaucratic competition and conflict to force issues to the top, maximizing the President's range of choice, close quote. That kind of policy leadership is impossible when important questions are resolved without ever reaching the White House or leaving the Environmental Protection Agency, for that matter. Because Roosevelt's revolution was incomplete in this respect, policy development and ultimate decision authority remained fragmented. All that advice, all those disagreements and options get filtered out in the departments and agencies. A decision is reached without the President ever having considered or even heard about the issue, let alone having balanced conflicting priorities in keeping with his vision of national policy. Madison was right, of course, about the imperial nature of the legislature. In Federalist 48, he wrote, "The legislature is everywhere extending the sphere of its activity and drawing all power into its impetuous vortex." Indeed, our system increasingly resembles the historical British system of parliamentary supremacy, and the framers most definitely did not adopt that. There, the executive and the judiciary exercise distinct powers, but only as agents of the legislature. Why, we might ask, did the framers disfavor that system? What did they understand that we have lost?